Your Honor, I fail to see the comparison between the misunderstanding that I had as to whom authorized my client to appear for a preliminary examination in a dignified manner, which I'm sure the court would agree was a good thing. And nobody had to tell me to come to the courthouse, to come to chambers and correct my mistake. I came on my own as soon as I clarified with the person who gave me the wrong information that it was somebody else that told them that. And I brought that to the court's attention. Those situations are absolutely, we have provided allowances for Mr. Pahaney. There was a exculpatory video that was not turned over, but for the fact that I was paying attention to what was missing from the video production, we would have never gotten that until the day of the preliminary exam and not been prepared for it. I didn't run to the court and say, hey, Mr. Pahaney's hiding evidence here. I've never done this before. I've never felt this strongly that somebody is being untruthful to the court in 28 and a half years of practicing law. I believe this is serious, and that if it's brushed over as a simple mistake, that more of this will continue to occur. Not just in my case, but in other cases as well.
Thank you. Mr. Morosky, anything else?
Hey, Your Honor, I just want to make a clear record. You can review the transcript, but I never said that I received an email regarding the subpoena that was laid upon Mr. Rooney or Mr. Amera. I stated that I received a subpoena from Ms. Krug on the juvenile matter, Your Honor, and for a clear record.
All right, Mr. Holman, anything else?
Nothing, Your Honor.
Well, notwithstanding the personality clash that's going on in this case, and various accusations that have been flying around since day one, I pointed out at the first hearing that I wasn't interested and still not interested in getting email between lawyers in which they're attacking each other and running each side through the mud, because it's all completely irrelevant to what I need to make decisions on. Those emails and various other attacks and statements have been not helpful at all. I don't know why that's happening in this case. I've heard why people think it's happening, but it doesn't quite pass the test that I need to have it affect my decisions. Maybe it's just strong personalities going on here. I don't know. But regardless of what I do, each of the lawyers involved has various other remedies and avenues to pursue whatever misconduct they think is going on. With regard to the joint motion to dismiss, my belief is that regardless of whether it was an honest mistake or an oversight or intentional conduct, and I'm not able to determine whether Mr. Pahaney's conduct was intentionally corrupt or malignant or bad, but the fact of the matter is that the attorney-client relationship primarily involved is between Mr. Berry only. We've had this discussion about standing and whether the cases are consolidated. We do have 3 separate cases here. They're consolidated for the preliminary exam, and there's other issues. Mr. Allen and Mr. Hallman still have complete standing to make objections under relevance rules, or I don't know if there might be a burden issue. I'm not sure, but you don't know. But they're definitely not precluded from arguing that the evidence received as a result of the material turned over by Rooney and O'Mara should be not applied to their clients. So if the court is going to allow the prosecutor to reopen the proofs in this case, and that's the next motion we're going to argue, that does not in any way preclude Ms. Buchholz and Mr. Pechette from arguing whatever position they have. It's just as simple as that, period. So the other issue that I've referred to earlier is that Mr. Pahaney has maintained that he had not spoken to Mr. Salins until after the preliminary examination. That would have been around the 21st, the exam's on the 18th. Assuming that's correct, Mr. Salen's represented Allison Majeski, who's not a party to this case. And the court rules say under MCR 2.305, a represented party, prosecutor, may issue a subpoena to a non-party, Salen's, for a deposition, production, or inspection of documents, inspection of tangible things, upon court order, after all parties had a reasonable opportunity to obtain an attorney. That's 2.305. The other controlling court rule, in my view, is 2.506, which, among other things, says that this sub-rule does not apply to discovery subpoenas or requests for documents to a party where discovery is available. But primarily, it's governed by discovery subpoena to a non-party, in my view. So, in that situation, I'm really not positive whether Mr. Bahani's report has served that subpoena or to provide any information with regard to that to any of the defendants. Clearly, Mr. Moransky, I believe, should be aware of the prosecutor wanting to communicate with his client's lawyers, but I'm still not convinced that, and I haven't seen any authority, and believe me, I've looked for it, I haven't seen any authority that says that failure of a prosecutor or a party in a civil case to provide a copy of the subpoena results in suppression or dismissal. It's not there. The rule doesn't say that that's a remedy, meaning suppression or dismissal. There's no statute that calls for that. The court can craft its own remedy, and I think that's probably what will end up happening here, but we haven't gotten to the ultimate motion yet. So, and whether or not the term outcome determinative only applies in certain types of cases, it seems to me that it applies here, and that's because the material obtained from the subpoena was distributed to all parties. And again, for the last time, Buchholz and Pechette still retain any argument for having that material suppressed or not applied to them. So, for those reasons, the joint motion to dismiss for prosecutorial misconduct or on the alternative to suppress is denied. Next motion is motion to reopen proofs in the preliminary examination. Mr. Bennett.
Your Honor has the background by which the people have asked to reopen proofs, in that the information that was received from Mr. Salen's, that being one side of the purported story, was corroborated once Mr. O'Mara and Mr. Rooney testified, and further so once the people served our subpoena ducis tecum. The reopening of proofs is within the discretion of the trial judge, or in this case, in the discretion of Your Honor, who is holding the preliminary examination. It is relatively commonplace to reopen proofs in a preliminary examination because there is no negative effect to the defense for doing so. Oftentimes, at the end of a preliminary examination, as the people move for bind over, the court may, at that time, and has in this court at the past, inform the people that there is not enough information for probable cause, and the people will make an oral motion at that moment to reopen proofs and continue the preliminary examination with further witnesses. Here, Your Honor, we're simply asking in writing for the preliminary examination to reopen so that Mr. Salen's can testify as to the agreement that he had between Mr. O'Mara and Mr. Rooney, and to explain the case from his client's perspective, that being that Mr. Berry would not return to the house during the pendency of the litigation. The people have cited authority in our motion that certainly allows the court to reopen the proofs, and would ask the court to grant our motion and set this for preliminary examination on the court's calendar.
I didn't quite understand what you said about, in this court, on previous occasions, you've asked to reopen proofs?
I personally have not, but Mr. Rukowski indicates that he has asked this court to reopen proofs at the close of an examination in the past, and the court has granted that oral motion. Mr. Rakowski does not recount any time that he's ever filed a written motion asking to reopen proofs.
Okay, I can remember maybe a couple times over 15 years that that's happened, but it was in the courtroom at the close of the exam, and the request was made. But in any event, Mr. Allen.
Your Honor,
Your Honor, if I
Okay.
could just, I apologize for interrupting, but I would note, Your Honor, that the response to this motion was filed and signed only by Mr. Morosky. It's not co-signed by the other defense attorneys. It would seem to me that Mr. Morosky would be the one to argue this response. And if Mr. Morosky is indeed the author of this, even though it certainly seems like Mr. Allen's writing style, I would ask that he argue it.
Hang on a second. It opens up defendants Berry, Buchholz, and Pechette in response. Oh, this is to the motion to quash the subpoena. Sorry, one second.
Your Honor, the people would note we received 2 copies of this motion, one served in person from Mr. Morosky, one served via email by Mr. Hallman. Both are signed by Mr. Morosky and only Mr. Morosky.
I don't believe I wrote that, Your Honor, and Mr. Morosky is welcome to argue it
Okay,
as well as I can.
just one second. I'm looking at filing made September 8th, 2023. And it appears to be, I've read it. 12 pages signed by Ms. Morosky. Is that what we're talking about, counsel? Ms. Morosky?
I believe so, Your Honor.
Mr. Allen, do you think that's what we're talking about?
It would appear so, Your Honor, but I can tell you, that is one I did not write.
Okay. Mr. Hallman, Mr. Hallman, I did not give
Yes,
you,
Your Honor.
I didn't give you more opportunity to respond to the motion to reopen. Anything else, Mr. Morosky?
I'll let Mr. Holman go
Let
first.
Mr. Hallman go. Okay.
Mr. Holman and I did work together on that motion, and I was my signature on that document.
All right. So I'm going to allow Mr. Morosky to make his argument, and Mr. Hallman. It's not clear whether it's not officially a joint motion, but I'm going to consider it as to all defendants because we've been talking about that all along. So, Mr. Morosky.
There you go.
Do you want a few moments, Mr. Morosky?
Yes, Your Honor.
Okay, so do you want like 5 minutes or so?
If we could, thank you.
We'll take a recess, and when you're ready to go, let me know.
Thank you, Your Honor. Into effect, Mr. Berry was never aware of any of that.
I'm never aware of any of what?
Of any agreement not to enter onto the property. You know, if you review the documents, there's no email stating from Mr. Berry's attorneys that he could not go onto the property, Your Honor. There's no email between Mr. Salins and or Mr. O'Mara or Mr. Rooney saying that he couldn't go on the property. It was a testimony of Mr. Berry's attorneys that he could enter the property. You know, and furthermore, if you look beyond the affidavit, there was discussion about mutual restraining order. This was an ongoing civil litigation process. It finally did come to a resolution, but there was no court order, nothing was signed, nothing was documented until June 22nd of 2023. And Mr. Berry, again, was never advised to stay off of the property located there in Kidney Road. And furthermore, the waiver was only to testify to matters that were testified to on the stand. It was not a general waiver, Your Honor. For those reasons, we'd ask this honorable court to deny the motion to reopen proofs, Your Honor.
Thank you. Mr. Hallman, anything else?
Yes, Your Honor, I'll be brief, but I think it's worth reminding, just for the record, that Mr. Berry is not charged with something that penalizes him for something he should or shouldn't have done in a misdemeanor or a civil infraction sense. None of the defendants, my client included, has been charged with felony home invasion, and that's the standard that the prosecutor must meet at preliminary exam as well. And that's the point that our response, I think, attempts to illustrate, is that even if everything, and I didn't mean even if, I'm sure everything in Mr. Salem's affidavit is 100% true, but the closest that Mr. Salem comes to reciting an order of the court is he mentions that there were conversations that the parties should not have any contact with each other, which is something that everyone in this courtroom knew before these charges were assessed. The parties knew, yeah, they shouldn't be around each other. Mr. Salem's affidavit does nothing to address the fact that on the night that my client and Mr. Berry and Ms. Buchholz were arrested, that my client had, or Mr. Berry had received no advice from his attorney at the time, Mr. Rooney, or the attorney before him, Mr. O'Mara, and that Mr. O'Mara and Mr. Rooney testified to. That at no time did they tell Mr. Berry, in fact, quite the opposite. They told him at all times, you do have a right to the property. Whether there were conversations that did take place that the parties should stay away from each other is irrelevant, Your Honor. And the content of Mr. Salem's affidavit is really irrelevant, considering the testimony of Mr. Berry's counsel, which is, of course, not to beat the dead horse, but that's where the authority that my client, Ms. Buchholz, also, that's where the authority they counted on came from that night as well. And, Your Honor, if there were anything in the affidavit, Your Honor, that would lead to relevant testimony, I know that Mr. Fahaney would agree, but we wouldn't have objected. Your Honor, there's nothing in here that would override the fact that Mr. Berry's attorneys both advised him he had full rights to the property, which on the night in question, which Your Honor has already heard ad nauseum. But that's what's relevant here as to whether any of the defendants could have formed the requisite mental intent to commit felony home invasion. Whether Mr. Salem can testify to the fact that the parties agreed at various times throughout a civil action that they shouldn't be around each other is irrelevant. You know, and all of these civil actions, I would imagine, of the nature that Mr. Berry and Ms. Majewski were a part of, civil action to addressing a property that was bought together and they're no longer together, the parties probably should always stay away from each other. But in that doesn't address at all whether felony home invasion could have been formed in the mind of the defendants. Thank you.
Thank you. Mr. Fahaney?
Your Honor, the standard of review that a court uses when determining whether to reopen proofs, and we're talking at a trial stage, not at a preliminary examination, is whether any undue advantage would be taken by the moving party and whether there is any showing of surprise or prejudice to the non-moving party. And that's from Bonner v. Ames, the 1959 case that was reaffirmed in People v. Collier on the criminal side in 1988. The people aren't taking any undue advantage here, Your Honor. The people are offering rebuttal testimony to two witnesses that, after a waiver of attorney-client privilege, gave us information that we would have never had access to but for the fact that Mr. Berry waived that privilege and allowed those witnesses to testify. There was never any talk of a limited waiver on the record, and there is, to the people's research, no such thing as a limited waiver. It's not, it's all or nothing. And to come back after both attorneys, when they testified in the exam, made an oral record that attorney-client privilege was waived, period. No limited to this hearing or only about this testimony, and no rebuttal would be allowed and no further discussion. There was no limitations. There was a waiver on the record in this court. Your Honor, the magistrate has not only the right but the duty to pass judgment on the weight and competency of the evidence, but on the credibility of the witnesses, and that comes from People v. Pale, a 1970 case from the Michigan Supreme Court. In order for this honorable court to have a complete picture of the facts of this case, the people believe it is imperative to hear from Mr. Salins to offer an explanation as to what he believed was happening during the pendency of the civil litigation. What the defense counsel seems to miss in paragraph 8 of Mr. Salins' affidavit is that he had discussions with Mr. O'Mara in regards to a written mutual restraining order between the parties. Mr. O'Mara did not wish to sign such an order because he did not feel it was needed. Rather, it was agreed upon the parties orally that Mr. Berry would not go into the home and that the parties would stay away from one another. That's Mr. Salins' sworn affidavit. They don't mention that part about where they agreed that Mr. Berry would not go into the home, and that's what Mr. Salins would testify to. The people on cross-examination during the preliminary examination with Mr. O'Mara asked him if there was an agreement in place between he and Mr. Salins as to whether Mr. Berry would not return to the property. Mr. O'Mara's response was, "I do not recall." The people asked a follow-up question to which Mr. O'Mara stated, "I do not recall any such agreement." So he didn't remember. This is the people's opportunity to refresh his recollection, as well as give the court a complete picture of the facts of this case. And we ask the court to grant the motion to reopen.
Thank you.
Your Honor,
Yes, go ahead.
there's 100 pages of communications that were produced in response to Mr. Pechette. There's not a single communication from either lawyer to Mr. Berry communicating this agreement that Mr. Rooney would not sign. And respectfully, we've cited the case law. The only exceptions to a homeowner being charged with home invasion, court order restricting access, abandonment of the property. In fact, the fact that Mr. Berry was hired a lawyer, was trying to get possession of the home throughout this entire litigation, and Ms. Majeski would not sell him the house, wouldn't allow the house to be put on the market. He did not abandon the property. None of that is going to be borne out by Mr. Salins coming into. I mean, I'm happy to cross-examine Mr. Salins, but he can come in and say that Mr. Rooney and he had an agreement that Mr. Berry would stand on the front on the corner over here with a sandwich board, extolling the virtues of Ms. Majewski. If there was no communication from Mr. Rooney to Mr. Berry about this, it's irrelevant. It's irrelevant as a matter of law because an oral agreement between two attorneys who, and no evidence that oral conversation was ever relayed to Mr. Berry, is like the tree that falls in the forest that nobody hears. The agreement isn't worth the paper it's not written on. And it surely cannot impose a 5-year felony charge or support a 5-year felony charge under the law of the state of Michigan, which states emphatically that as a joint tenant with full right of survivorship, Mr. Berry had a 100% undivided interest.
Your Honor, the people are
in
going
the
to
property.
object because this issue was not raised in the motion to reopen proofs. This is a matter of law, that'll be considered when the court hears the entirety of the preliminary examination evidence. It was not briefed, it was not answered in this motion, and that is what's irrelevant today. What the court has before it is whether to reopen the proofs in this preliminary examination, not make a decision on a matter of law relating to the ownership of this property or whether the crimes have been committed. That comes at the people's motion for bind over.
Your Honor, before Mr. Pechette had interrupted me without the court's permission, I was going to finish my thought.
Go ahead.
Which was to say that it is not it is not irrelevant to the court's determination as to whether or not the proofs should be reopened in this case. That the case law does not support what he is bringing this witness in to testify about. It's a waste of the court's time to have Mr. Salins come in here, waste of my time certainly to cross-examine, which I'm more than happy to do. But if there was an agreement, if there was an agreement between counsel.
I understand. You don't know. We don't know if it
We don't.
was passed on to Mr. Barry. I get that completely. So, as Mr. Pechette had stated, with regard to the standard to be applied to reopening proofs, whether to reopen proofs for a party rests within the sound discretion of the trial judge. That's Bonner v. Ames. This is ironclad law in the state of Michigan. 356 Michigan 537, People versus Collier, another leading case that's still fully valid. Relevant in ruling on motion to reopen proofs in a civil case. The civil case is the timing of the motion, whether the adverse party would be surprised to see if there's disadvantage by reopening the proofs and whether there would be any inconvenience. In a criminal case, the relevant consideration is whether any undue advantage would be taken by the moving party and whether there is any showing of surprise or prejudice to the non-moving party. I don't see any undue advantage being taken. It came immediately after the two lawyers testified, and there's no prejudice that's taking place as a result of reopening the preliminary examination for the sole purpose of hearing from Mr. Salins, or I suppose any other witness that's going to show up. But Mr. Allen, you talked about the illegal entry portion. There's also this amended conspiracy count that the people have asked for, and I believe that that Mr. Salins' testimony is possibly relevant. I don't know if it is relevant, but it is possibly relevant as to the amended count added for the conspiracy, which is to commit a legal act in an illegal manner, meaning what was Mr. Berry's intent when he went into the home? That's the way I read the law. And so I think that that amended charge that the prosecutor asked for, I think it's perfectly possible that it could be irrelevant with regard to knowledge, intent, motive, those types of things. And so I think it's appropriate to reopen the exam, hear from Mr. Salins, see whether it applies, and it does apply to Mr. Berry only. At this point, there's no information at all that relates to Ms. Buchholz or Mr. Pechette. This is solely related to Mr. Berry. You agree with that, Mr. Pechette?
I do, Your Honor.
So, that's the order of the court. We'll finish up the preliminary examination. Can we get a date, please, Madam Recorder?
I will just start with the court's next available, which will be Tuesday, October 3rd. So that'd be a week today.
Anybody available next Tuesday?
I have a motion for summary judgment, Your Honor, on that day.
I am not available, Your Honor,
Okay.
on that day.
And neither am I.
Friday, October 20th. We can be a little flexible, but I would say 9 a.m.
That's kind of early, I'm thinking, for Mr. Allen, Mr. Holman.
I could stay at my place in Port Austin, Your Honor, but I am in Traverse City the entire week for the Michigan Municipal League Conference.
what I'm gonna do is, I'm gonna leave it to
Yeah.
council to figure it out, and I'm gonna step away. Anything else, Mr. Mahoney?
Nothing from the people you're on,
Mr.
thank you.
Nothing, Your Honor?
Mr. Mosky?
No, Your Honor.
Mr. Holman, anything else?
No, thank you, Your Honor.
Bond will continue, thank you all. Off the record.